number 50, the people of the state of New York versus Andrew R. Bushey.
Good afternoon, Your Honor. Barry Colvin on behalf of defendant appellant Andrew Bushey. I would respectfully request 2 minutes for rebuttal.
You may have 2 minutes, sir.
Your Honors, we are respectfully asking that the court find that Article 1, Section 12 of the New York State Constitution requires that law enforcement officers have an objective, credible reason, not necessarily indicative of criminality.
What's the defendant's expectation of privacy in the information related to that plate? I mean, the plate, you're not arguing he has an expectation of privacy in the plate number?
No.
Okay, so what's his expectation of privacy in anything that can be accessed based on the plate number?
We believe that he has an expectation of privacy, and we all do, in the personal information that the DMV or any other governmental entity has in a database.
But what personal information is it? It's whether your car is registered or not. I mean, isn't that the entire purpose of having a license plate?
Also, your date of birth, social security number.
But that's not what happened here. He ran the plate, he got a license plate hit back saying that car's not registered. It wasn't that they used his personal information for something.
No, but he did testify that he did receive his personal information, and the average person who's on the roadway should not be concerned that a police officer... Should that be a personal lawsuit, then, instead of suppression of the running of the plate for a legitimate purpose of getting the registration or not? I mean, wouldn't that be... You improperly access my date of birth, so there's some kind of right of action based on an invasion of privacy? Well, I don't think that there's a deterrent effect then. If you just have the ability to sue somebody, then any case where we have an exclusionary rule would be undermined, and we would take the position that you can always just sue as a civil rights violation, so why bother having it suppressed? In this case...
If he ran the plate, or runs the plate, he sees the violations, but doesn't go after him, is there a violation of the defendant's...
I would argue that there is his right to privacy, because you have that individual's date of birth, home address, phone number, personal information.
Just by looking at it, we'll assume for purposes of my hypothetical, the officer does nothing with that information. Well, if just out of curiosity, I looked at it.
Yeah, then it's a minimal violation of expectation of privacy, but there's still an expectation of privacy that individuals have in that personal information.
To get a driver's license, he voluntarily provided his date of birth to the Department of Motor Vehicles, and they can use, I mean, what expectation of privacy does he have in that?
In order to get a driver's license, you have to give that information to the Department of Motor Vehicles.
He chose to. We didn't have to get a driver's license.
That's correct. And then we have a federal statute, 18 United States Code, Section 2721, that indicates that there are criminal and civil remedies if anybody at DMV's state or nationwide violates that confidentiality of those DMV records unless there's a lawful reason to do so. And in this instance, we believe that there was no lawful reason to do so.
So the officer violated that statute?
I believe he did. And there are lawsuits across the country where the people believe that...
Then to Judge Garcia's point, you have a remedy.
Well, but we believe that the remedy here, the strongest remedy, is to the deterrent effect of suppressing that information, suppressing then what he subsequently receives as fruit of the poisonous tree, pulling over the vehicle.
What case are you relying on for that proposition, counsel?
I'm sorry?
What case are you relying on for that proposition?
I'm asking that the court find that under Article 1, Section 12 of the United States of the New York State Constitution, that this court find that. I'm not relying upon a case that says that there's an exclusionary rule. There are cases in Virginia, Florida, and Oregon where those courts have held that there is the ability to suppress DMV records based upon a violation of the privacy of that individual.
What is your basis for saying that there should be a distinction between the federal and state constitutions here?
Because, as the court is aware, the New York State Constitution is not only protective of places and seizures at places, but also of the right to privacy. And this court has repeatedly upheld the right to privacy. As a matter of fact, in People v. Weaver, this court held that a publicly followed vehicle with GPS on it, even though it's going to places that are all public, that the collection of that data is protected and it violates that individual's right of privacy.
Well, but in Weaver, we talked about a situation where technology allowed you to get more information, the police to get more information than they could have gotten otherwise. Here, couldn't the officer simply have, called dispatch and asked them for the information, or gone to DMV and gotten the information? I mean, I don't see how this is a Weaver technology issue.
Well, we argue that they could only do that if they have a lawful law enforcement function to do so, that there has to be an articulable basis for their inquiry at DMV for that information, to get the personal information of any individual. We shouldn't be concerned that when we drive around public highways that and violate no laws, don't and do anything
Was he driving
wrong.
on the public highway? Could it be considered a trespass, the area, the road that he came in and then came back out? Was that
There was-
private property? Was that the university's property?
There was no record established here that that was private property at all. And then he followed the vehicle for 2 more right-hand turns, and there was no allegation that there was any erratic driving, violation of any vehicle and traffic law. And we should be very concerned that police officers not have the ability to just observe a vehicle on a road and decide for no reason other than just whim, caprice.
Could the officer have just gone down the street where all the cars are parked and run all those plates?
Well, that's not the case here, but it depends on whether they were doing, that officer did so in a non-arbitrary, non-discriminatory, objective manner.
So would that also apply if the officer, in this case, the officer manually put in the license plate, right? So if I believe they have some automatic readers that a police officer can sit by the road and just let cars go by, and their license plates are being read, and if something comes up, like in your client's case, the registration is suspended, wouldn't they be able to stop someone
Well, that's
based on
different, and that depends on the
Why is that
technology.
different?
Because that may have memorandums that the officers are abiding by, which indicate that they're non-discriminatory, non-arbitrary criteria for how the officer uses that technology.
So-
I think this is all dependent on the tech.
So, Mr. Covert, you're arguing essentially that for an officer to run a plate, you want to basically establish a DeBoer type review?
Correct.
A level
The
1
lowest
DeBoer.
level.
You want to have to run a plate now, not to stop someone.
That's correct. To run a plate, we want to have the lowest level, same as Ingle, where the court held that it's a minimal level.
Well-
And in Ingle, the court said it could be a dilapidated vehicle that's not in violation of the law, but some
It was a
articulable
stop,
basis.
though, not running the plate.
That's correct.
I think analytically, it's a basis to stop is a much different thing. He had no basis to stop here until he had the suspended registration.
And in People v. Weaver, they didn't stop that vehicle either, but they followed
I
and
don't know if
collected that
Weaver-
information.
I'm not sure that Weaver really helps you, but I just want to be clear. So that's your argument, level 1 DeBoer, that's what you're looking for?
That's correct, Your Honor.
Okay, all right.
So
I got
we
it.
believe that thank you.
Counsel?
Good afternoon, Your Honors. Ray Herman for the respondent. I think this does point out that it's really the only question here is there a reasonable expectation of privacy in such a database?
Do we know from the record what information was available to this police officer when he ran the plate?
Not really. All he said is personal information.
Does it matter?
Well, I would say if there was something, I could possibly matter, but as far as I can tell from the statute, I cited the statute, when you want to register a vehicle, and I think it's fair to look at the statute, you basically have to give your name, address, and I believe probably a birth date. So this whole thing about social security numbers, I don't see it in the statute, but this is created, when you register a car, it's not a right, it's a privilege to be on the road, and there's a very strong interest in the state.
And what is the actual database he's accessing here? What is it?
Well, it's the DMV computer, that's what he's accessing, and that's my understanding.
And it will tell you who the car's registered to, whether the registration is current, obviously, it tells you that.
Right, and it would tell you who the registered owner is. But I would say that when you run a plate check, it's not like you're focusing on a person, you're focusing on the plate number, so there could be someone else driving the car. So I think that the police should have access. Basically, the council is asking you to create a state constitutional right that's never...
When you give this information to DMV, where do you get the concept that you expect that anybody, any cop, has access to it when you've done absolutely nothing wrong?
Because you're on...
You're behind the wheel, done absolutely nothing wrong, because the cop admits there wasn't anything unusual, I just ran the plate.
He just ran the plate. I would say that...
Is that really true? There was nothing unusual about it, Mr. Herman? As I remember the facts, it's 3 o'clock in the morning, the car's coming down Elmwood Avenue. he made a turn into the turnaround and then clearly had made the wrong turn and came back out. Isn't
Well,
that
that
the
is, Judge,
circumstances?
that is the facts. I actually did, well, I argued it in the trial court. I did make that argument. The officer also said, you know, well, a lot of people make that mistake, so I suppose there was some reason.
It wasn't
but-
out of the ordinary, in other words.
That's what he said. It was not out of the ordinary for someone to do so. But I would say, you know, like, for instance, I drove from Buffalo today. I have no reason to believe that someone didn't do plate checks on my car on the thruway. And really, I honestly don't think that I have any expectation that that would not happen.
How do you avoid the potential for abuse?
Well-
An officer who chooses only to run the plate for a certain class of driver.
Well, Judge,
I
that,
only want to run the plates for those female drivers. I'm worried about them on the road.
Judge, that always could be a problem, but I don't think enacting a new constitutional right really changes anything. You could say, I'm only going to stop the females that commit vehicle and traffic law violations. So I don't really think that prevents that at all. So just to kind of wrap things up here,
Well, no, his argument is you have to have some basis to do it. You can't just do it because you just want to do it.
Well-
Doesn't that get to the question of abuse? You're avoiding the abuse because the officer, as in any interaction with someone, has to have, even at the low threshold, a reason to choose that person. Why
Well-
choose that car?
well, the officer's choosing that vehicle just because, well, it goes back to whether a person would feel that they're driving on the road, that the officer could not access their plate arbitrarily. And my answer to that is, I have no reason to believe that a motorist, having voluntarily, the owner of the vehicle, surrendered this information to the DMV, would not access.
Is it in part beyond that expectation, the difficulty of catching people who have these kinds of violations?
Well-
If you can't do these kinds of
Well,
runs
yeah,
as
of course. I mean,
cars go
that's not-
by?
Judge, that's an excellent point. I mean, you know, we need to stop cars that are not registered, because usually it's because they don't have insurance. There's a lot of reasons that a vehicle should not be on the road, and to create some level of justification, which, by the way, I couldn't find any case law upholding such a concept. In fact, the case law pretty much says, that's out there, says that you can do these plate checks. And this is not a case of new technology here. These plate checks have been going on for a long time.
Is this different from DeBoer, since DeBoer involved a seizure, whereas here, there's no seizure when the information is
Well,
accessed,
yes,
right?
yes, Judge, because we don't have a encounter with a person. That's a huge difference here. When you're running a plate, it's very different than stopping a vehicle or even approaching an individual. You're targeting a person, whereas running a plate is just accessing a database of information that the owner
Well,
already.
you're not checking their movements with some system as was happening in the GPS cases. What you're doing here is identifying a vehicle where there can't be any expectation of privacy. But I'm just wondering if there has to be any circumstances. Can the police do it in any situation at all, or are there specific articulable circumstances that would confine their ability to run the plate in this situation?
Judge, I would have to say no to that.
By no, you mean, Mr. Herman, they could run a plate at any time,
They could run a plate.
and
Now,
that you have no expectation of privacy in it at all.
yes, that's my simple answer. And of course, as been pointed out, there are these plate readers. Now, apparently, my opponent does not feel that that's an issue. I think if you're going to say that going to create a state constitutional right here, then it has to apply to those plate readers, and because they're.
I thought his point is that it's not choosing this particular car. The discretion is taken from the officer. It's just everybody that's going by, it's on the car. You don't have to worry about the potential for abuse.
True, Judge, but you're still accessing, if they feel that this is private information that shouldn't be arbitrarily accessed, that instrument device is accessed.
In any of those cases, counsel, where you've indicated that the courts have decided that a license plate, there's no expectation of privacy in a license plate. What have they said about the databases that the license plate is linked to?
Well, there's really not much out there on that question. The database under that federal statute, which I point out in my brief, has been restricted. The access you have is restricted, but there's an exception for law enforcement. I think the reason that they passed that federal statute is because there was no constitutional claim here. They decided to create a privacy interest via a statute. Now here,
Do you think as I remember in city court, I thought the basis for the judge's decision there was basically that this is, she used an Engel analogy, is that correct?
she did cite Engel, which this has nothing to do with Engel because it's not a.
Okay. Are we restricted in any way by that decision?
Well,
in other words, are we restricted to the question of whether or not Engel applies to this?
well, I certainly would argue that that's, you could look at that, Judge, because she didn't, the record here is very, very skimpy.
Well, I understand, but.
So,
What, can I ask you, since you say it's, at least there's not any record testimony or information as to what the officer, what the information was, other than what he testified to, that the officer could see when he ran the plate. Let's assume for one moment that it had personal information. Let's say it had information that the person is an epileptic. People have epileptic seizures, get licenses, they get confirmed. What if there was something like that? Is that a different case?
I would still say no, Judge, because they're only collecting information that they need to collect, and the DMV doesn't, if that has nothing to do with registering a car, I don't believe they would even be collecting.
So if it was the kind of information that for whatever reason DMV may need, but that one who gives that information doesn't think, well, that's the kind of information anybody can have access to, or police officer, not anybody, a police officer could have access to, because they don't need it for purposes of figuring out whether or not I violated any VTL requirement or registration requirement. Is it a different case?
Well, again, I really don't think that is in the information. I do think.
No, but that's not what I asked.
Okay.
It's a hypothetical.
Okay.
Since we don't know really what's there.
We don't know what's there. I would just simply say that based upon the facts, I don't think that that's a case where it's an information that would be in the records.
Thank you, Mr. Herman. Mr. Covert?
Yes, Your Honor, thank you. I think Mr. Herman just, if I heard him right, did concede that the database, the federal law, has now restricted the database, the DMV databases nationwide, and he indicated also it creates a privacy interest. And I believe that those were his words, and I think that that's exactly correct.
That doesn't apply to law enforcement.
But it does, because there's only an exception under the federal statute for law enforcement when they're performing a law enforcement function.
Well, isn't that performing a law enforcement function to make sure that a car is properly registered? Car on the
Only-
highway is properly registered?
Only if they do so non-arbitrarily without discriminating. And I believe that when they do so arbitrarily, in this case it was on whim, caprice, and just out of pure curiosity, the officer could give no reason whatsoever for why he ran that license plate. He was given the opportunity. He quite candidly stated that there was nothing unusual about what that vehicle did. And so I believe that there should be a minimal threshold. It's not de minimis level of expectation of privacy, but a minimal, a lower level of expectation of privacy that we should have that requires him to come up with some reason, any articulable basis to to run that license plate, which led to the vehicle being pulled over and then these charges. So I very respectfully ask that the court find on behalf of our client. Thank you.
Thank you, counsel.